This one you probably wouldn't believe unless you had sufficient faith in me as a barrister helping you to understand law on this channel. And that is that thought crime now exists in the UK. Let me say that again. Thought crime exists in the UK. That is what you think may be a criminal offence, depending on the circumstances. Now, I'm not talking about an act of preparation for a crime, because an attempted offence or an inchoate offence, which is an offence that is not yet complete. For example, you're planning a burglary, or you're planning a robbery, or you're planning something else. You might have various thoughts about that. You might have researched something and not yet actually done anything. Now, with those kind of offences, they have to be more than merely preparatory. So instead of just preparing to do something, you have to have taken some steps towards that offence. So let's say you've researched something but done nothing more. That's not necessarily going to land you in any kind of trouble. Unless, of course, it's to do with some kind of terrorism offences and things like that. But by the by, if you have done something else which is more than merely preparatory, you might be charged with and maybe even convicted of an attempted or inchoate offence. That is, as I say, an offence which hasn't yet happened, but you've been more than preparing to do so. This is a little bit different. Now, to explain this, I need to explain, as I've explained in previous videos, that local authorities have power to create laws of their own. They can create bylaws, and they can now create what's known as a public space protection order, which is a little bit like an injunction within a certain area to prevent certain activities from happening. Now, I've talked in other videos about how these shouldn't be used, they can't be used, they can be challenged, and that they shouldn't be used where they conflict with other existing laws. But in certain cases, when they implement one of these public space protection orders, if it doesn't go challenged, then you can't challenge the validity if you're outside of the initial 6-week period. However, if you are convicted under one of these, it is possible to challenge that conviction on the basis that it was unlawful in the first place, possibly by a judicial review or having your case re-examined by way of case stated. But what we have here is a public spaces protection order put in place by Birmingham City Council that restricts and makes criminal something that you might merely only think in your mind. Allow me to explain. Now, there's a medical facility known as the Robert Clinic on Station Road in Birmingham, which carries out abortions. Now, some people agree with those and some people disagree with those. This video is not to debate whether those are correct or not, and I'm not expressing any view on whether those are correct or not. My angle is simply on the legal application of what this order has put into place vis-a-vis restrictions around that clinic. I will link this document in the description below, and on page 2 it has a list of activities which are prohibited by this order, and failure to comply with this order will amount to a criminal offence. In fact, one lady has been charged and due to appear in court for praying outside this clinic. So looking at these activities that are restricted under this order, number 1, protesting, namely engaging in any act of approval or disapproval, or attempted act of approval or disapproval, with respect to issues related to abortion services. By any means. This includes, but is not limited to, graphic, verbal, or written means, prayer or counselling. Now, if we break that down somewhat, this is a medical facility, so it's quite right that the local authority would look to restrict people interfering with people going to that medical facility, potentially because they strongly disagree or whatever. And so this first part of this order restricts graphic, verbal or written means of approval or disapproval. On the one hand, you could say that's sort of fair enough because it could amount to harassment of the people going to that clinic. On the other hand, some people will believe that that's interfering with their right to protest. However, there isn't any such right as such to protest. It's more a case of the freedom of assembly and the freedom of expression, which are qualified rights under the ECHR. Now, a qualified right is something that the local authority and national authority can interfere with if it's a justified and legitimate means of interfering with your rights and freedoms under ECHR. So whilst it's not an enshrined right to protest, there is a freedom to express your views. But that freedom to express those views can be curtailed and interfered with if the authorities believe that it's a legitimate cause to do so. That's precisely what's happened in this document, because the Birmingham City Council has made clear that the council has regard to the rights and freedoms as set out in the European Convention on Human Rights, and the council's had particular regard to the rights and freedoms set out in Article 10, which is the right to the freedom of expression. So as I say, it's the right to a freedom, which is sort of a contradiction in terms, really, but it's the right to freely express what you wish and the right of assembly in Article 11. But as I said, the authorities can interfere with that as such they choose. The council goes on that it has concluded that the restrictions on such rights and freedoms imposed by this order are lawful, necessary and proportionate. So the local authority, Birmingham City Council, has considered the ECHR implications and concluded that it's a lawful interference with your right to the freedom of expression and the right of assembly. However, whilst the restrictions on graphic, verbal and written means of approval or disapproval around that area might be more understandable, the bits that many of you might have an issue with are the last two, which is prayer or counselling. Now, of course, prayer can happen in your mind. It doesn't have to be out loud, which would obviously be verbal. It could simply happen in your mind. And according to the report that I read this morning, that's precisely what this lady has been arrested and charged with. Silent prayer and thought in her own mind. Now, for me, this PSPO is also interfering with Article 9 of the Convention, which is the freedom of thought, conscience and religion. Article 9 provides that everyone has the right to freedom of thought, conscience and religion. This right includes freedom to change religion or belief or freedom either alone or in a community with others, and in public or in private, to manifest his religion or belief in worship, teaching, practice and observance. And secondly, the freedom to manifest one's religion or beliefs shall be subject only to such limitations that are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So clearly this is also a qualified right in that the local authorities and the national authorities can interfere with this right under Article 9 as well. In fact, the courts have held previously in Europe that in certain cases the freedom of thought can be interfered with if it does interfere with the rights of others. And this order goes on. Secondly, it provides that interfering or attempting to interfere, whether verbally or physically, with a Robert Clinic service user, visitor, member or staff. That's fair enough. Interfering, whether verbally or physically, ought to be restricted. Thirdly, intimidating or harassing or attempting to intimidate or harass a service user. Fourthly, recording or photographing a service user or visitor, member or staff. And fifthly, displaying any text or images relating directly or indirectly to the termination of pregnancy. Now, all of those things are something physical, either doing something, saying something, interfering, harassing, using text or imagery or verbals or all this kind of thing. But the one that many of you might find quite shocking, and many of you might disagree with, is the silent prayer aspect to all this, because after all, there is the right to the freedom of thought and religion. But what this is ultimately saying is that if someone is standing outside conducting silent prayer in their own mind, they are liable, if it's confirmed that that's what they are doing, to arrest and charge for breach of this order. And reportedly, that's precisely what happened earlier this month to Isabel Vaughan Spruce, who was standing silently in a public street, and when asked by a police officer whether she was inwardly praying, when she said she might have been, she was immediately arrested, taken to the police station and searched. And she now faces prosecution for breach of this order. So the upshot of all this is that if she's convicted, she'll have a criminal record and have to pay a fine of up to £1,000, because this order prevents any act of approval or disapproval, even if it includes your own silent thoughts. As part of her bail conditions, reportedly, she's been banned from engaging in public prayer, even outside the bounds of this PSPO area. So she's effectively been banned as part of her bail conditions from having silent prayer and thought anywhere else. Now, as a barrister, of course, I support law that will help to support and keep the peace and protect everybody's safety and living together as a civilized community. But this is one area that I think is going to have quite significant ramifications and is a little bit of a slippery slope where local authorities start to legislate and put in orders which will criminalize certain thoughts when they simply form part of a person's personal religious beliefs. Now, of course, the obvious argument is that anyone that has these thoughts shouldn't be going to those areas and standing outside having these private thoughts. But the real question is, how far does that go? Because this PSPO is in that particular area, but now her bail conditions reportedly have said that she's not allowed to have silent prayer anywhere else out in public, outside the bounds of this PSPO. Personally, if that is the case, and those are her conditions, I don't think that's lawful. I don't think it will be lawful to restrict somebody from ordinary prayer out in public if they are outside the bounds of this area, irrespective of whether this particular order is valid and legally enforceable. Which, as I said, there are probably some grounds that this could be challenged at a judicial review or even by way of case stated to get at the very heart of whether this order is lawful at all. But in the meantime, anyone that is in or around this particular area, of course, I would suggest that you comply with this order, because otherwise, if you're found to be in breach of this order, you're likely to be arrested and charged as well. And it will be a very difficult and expensive process to try to challenge any such conviction on the basis that the order was not legitimate in the first place. There are routes to challenge these orders, and they're supposed to be done within 6 weeks. Otherwise, you can't challenge it until the order expires, because they are time limited, and then challenge it again when and if it's renewed. For anyone that wants to challenge a PSPO, a Public Spaces Protection Order, there is an appeal route, and the provision is within the Antisocial Behaviour, Crime and Policing Act of 2014, specifically in Section 66, which creates a specific statutory appeal route which must be followed by interested persons. Those are usually those that live or work or regularly visit the relevant area. The deadline for issuing a challenge, as I said, is 6 weeks from the date the PSPO is made, and the relevant venue for such a challenge is in the High Court. There's no permission stage. You can go straight to the High Court. The challenge would be on the grounds that, first of all, the local authority did not have the power to make the order or the variation or to include a particular prohibition or requirements imposed by the order, or that the requirement under the statute was not complied with in relation to the order. And the Act explicitly prohibits interested persons from challenging this PSPO by any other route other than the Section 66 procedure. However, a standard judicial review is not ousted for those who do not have an interested person status. In other words, if you are one of these interested parties, i.e. you live or you work or you regularly visit that area, you are supposed to use this Section 66 appeal procedure to the High Court within 6 weeks to challenge the validity of the PSPO. And there are some very interesting articles of where judicial review has been used to challenge the validity of a PSPO. I will link one of those articles in the description below, one of which relates to dog walking, and ultimately the judge was required to interpret Section 66 and establish the level of the review, the judicial review, that was to be applied, ultimately concluding that the Wednesbury principles applied. If something is Wednesbury unreasonable, then it's so unreasonable that no person of sound logic and reason could have made that decision. So as I said, I'll link that article in the description below for those of you that want to go and read that. And so there it is. It's very real. There is an order that prohibits what you are allowed to think in a certain place. So of course, if you are aware of these orders, I would obviously recommend that you comply with these orders unless and until they are challenged. And of course, let me know your thoughts and comments in the description below. So far as I'm aware, there's no crime yet in you putting your thoughts down in the description below. Unless, of course, they amount to malicious communication, they amount to threats and harassment and intimidation and all those kind of things. But your thoughts, I welcome. Please do remember to like the video and subscribe, and I'll see you next time.